SLP petitioners before your Lordship in this particular petition. None of them were parties before the High Court, and we've therefore come here with leave to appeal this particular judgment. Now, I come in what can be broadly described as that untainted category, and this is very important. So 2 points I'll make straight away. First, I'm in the class 9 and class 10 band of assistant teachers. Second, I am not, in a manner of speaking, tainted either by the OMR issue or by the rank jumping issue. Nevertheless, the impugned judgment in para 363, Roman 2 says, all appointments granted in the selection process involved being violative of Articles 14 and 16 of the Constitution are declared null and void and cancelled. So one more fact I want to mention. At page G of my list of dates, I have given you the dates, so I'm not going into those specifics. I was appointed in 2018 and 2019. There are 3 petitioners. So between 2018 and 2019. I've been in harness for more than 5 years. Apart from being in harness for more than 5 years, Manoj, we've taught over there as assistant teachers in class 9 and 10. There's absolutely nothing against me. There's no finding. I'm not on any list of any CBI or anybody at all. Now, in this backdrop, let us go back to this paragraph 240 for a moment and just study it a little carefully. The 3 bands in para 240, which I understand is at PDF 252.
Yes.
Now, let's see these numbers. I'm on the first band of assistant teachers. 11,610. Now, I ask, the question I pose to myself is, could this have been done through an executive order? I believe if it were done through an executive order, this type of cancellation, that everything is going out, your Lordship should have struck it down as treating unequals equally, which is completely wrong and has been frowned upon. Now, out of 11,610, the OMR issue, assuming there is an OMR issue, is only for 808. Now, look at the second column, rank jumping. I am not, as I mentioned, I am not on the
OMR issue is that the OMRs were not available.
There were some blanks, there were some available. But this is only what now, this is post, whatever the value of that investigation by the CBI.
On what basis did the SSC submit this statistical report? Now we are taking this report.
Because there were lists which were filed by CBI, for example, which were there. That list is also appended in annexures to this document.
Are those OMR sheets recovered from the residence of that Mr. Pankaj? That's the start and the end of the CBI's investigation. The CBI says that in some of those OMR sheets, some people who have got 0 have been selected. Now that's the whole case of this. So if that record which is recovered from the residence of that gentleman and that certificate has been attached.
How many OMR sheets have been recovered from Bansa's residence?
Number is there is no number given. There is no number given anywhere. If you watch, will read the last of the CBI. The scanning was done. The board was to scan. Board A to scan. Agency A gave it to agency B. This Pankaj is the employee of that agency. Then some employees of that agency split and make their own practice. And then Pankaj goes and joins those employees. And he has given a certificate as an employee of that split agency on the basis of record which is recovered from his house. And 25,000 people are losing their job. That is the whole open and shut case finished. The judge has addressed no other argument which was raised before him. And how did we lose our job? The single judge who was hearing the case, one order says, this is a case where the board should exercise power under 17. 17 is a power with the board to withdraw recommendation. The board says, yes, we will look into it. We immediately file an appeal before the division bench. And we tell the division bench that we have been working for 4 years. Single bench in a 1-page order says, board to look into it and exercise power under 17. Division bench says, yes, you have no right to be heard. Finding number 1. Finding number two, 17 will apply. The same day when the division bench passes the judgment, the same day the board passes an order withdrawing our recommendation. And the next day our services are terminated. We come before this court here. Your lordship stays the termination. Your lordship stays the termination and says they should have been heard. And your lordship says, please go into the issue whether Rule 17 at all applies after a person is appointed and has served for 4 years. Now, all those arguments are raised, not a single word on Rule 17. The petition challenging the vires of Rule 17 is separated, segregated, and not decided. And the whole judgment is based on this 65B certificate.
Mr. Patwalia, Bansal signed the certificate in what capacity?
My lord, as an ex-employee, just kindly see one paragraph of, just one minute. Just kindly see one paragraph in the judgment, para 305. The whole cat will be, just see para 305 to answer this question of my lords. Who was authorized, who did it, and who gave the certificate? This is a matter, Lord.
Para 15. Yeah. Certificate is at